All right, welcome everyone. I'm Jeff Segal. I'm CEO and founder of Medical Justice, focused on keeping doctors from being sued for frivolous litigation. In addition, we also pay a lot of attention to assault on reputation, particularly online, and a host of other medical legal conflicts, thorny issues. I'm both a physician and an attorney. And today we're going to chat about the indignity of being sued for medical malpractice. All right. So, one question that popped up on a physician forum in the not too distant past was this: why do doctors treat medical malpractice differently than being involved in an automobile accident? At the end of the day, shouldn't we just not worry about it and turn it over to our insurance carrier? Indeed, isn't that why we have insurance, so we don't have to think about it? Well, the answer is no. The two systems are different. They have very little in common. And here's how it opens. If you've ever received a medical malpractice lawsuit, it starts off as an assault on your reputation. This is a typical summons. I mean, it's not unusual. It'll start with, hey, with willful and wanton neglect, you hurt Mrs. Smith. She's damaged and can't enjoy daily life. She can't go back to work, has horrific medical bills, perhaps even passed away. But here's what you will never see in a summons: that you are a talented doctor who made a one-time mistake. We understand that you're a human and care deeply about your patients, but with Mr. Smith, the injury has cost him lost wages and future medical costs. Now, that is inviting, and if I actually saw something like that, I would be open to trying to understand what could be done to make it right. There are systems around the world, in particular Sweden and New Zealand, where there are no fault systems. These are systems where the doctor and the patient can actually sit on the same side of the table and try and come up with a solution that works for everyone. It's not a name, blame, and shame system. And our system, unfortunately, does seem to have that aspect. There are exceptions to the rule in some states. There are some hints of a less adversarial approach. For example, in Colorado, there is a mechanism where the doctor and the patient, with their attorneys, can exchange information in a non adversarial way. And to the extent they come up with a reasonable solution, the carrier will write a check, and that will not be reported to the medical board or the National Practitioner Data Bank. So this is one of the very unusual systems that are out there, and it's not without its own flaws. But let's go back to what I was talking about. Why don't we just turn it over to our insurance carrier and be done with it? All right. So the two systems don't have a whole lot in common. What they do have in common is that you'll be tried by 12 laypersons, but here the analogy falls flat. The individuals who are paying attention to your case know very little about medical care. You're not being tried by a jury of your peers, you're being tried by other citizens. And I've heard it said cynically that these are people that didn't know enough to get out of jury duty. I take exception to that. In fact, I served on a jury for 1 week. It was a case about child molestation. It was a criminal case. And they probably had about 100 people show up to the pool. And they kept asking people, do you think you can um, rule on this fairly and objectively, particularly if you're a parent? I mean, the case was challenging. I mean, you're talking about a someone who's 12 or 13 getting abused by a step parent, and it's emotionally laden. And I said I thought I could rule on it. So even though I was an attorney and a physician, I was selected, got a chance to spend a week in the jury, and it was quite an interesting case. But in any event, the other things that are different is that a medical malpractice case will be a battle of the experts. You'll have people on both sides talking about what the standard of care is. And if the jury doesn't actually know much about medicine, they may be more swayed by charisma or their performance capable or the expert's performance capability. as opposed to the facts. And then finally, the outcome might cost more than you have in your policy. So that may be one reason you may be concerned about just turning it over to your carrier, because while they're not going to settle for something more than your policy limits, it could be that if things fall flat, it may anger the opposite side and they may be looking for more than your policy limits. For most doctors, they carry $1 and $3 million worth in coverage, $1 million for each event, $3 million for aggregate events in any one given year. And while it's unusual for a plaintiff attorney to demand, or settle for more than a policy limits for more than $1 million, if a patient has a significant life care plan and you're the only defendant, they may feel the need to keep going, particularly if you've irritated them, if you've pissed them off. So anything's possible, and there's a great deal of risk in the professional liability system for physicians. Next, to defend yourself, it's a lot of work. You're going to have to spend a fair amount of time prepping for and being in depositions. Not only the medical events, you'll need to understand what took place medically and how others may have taken care of and followed this patient after you were long gone. But you'll also need to understand how to do a deposition. It's not intuitive how to do a deposition. In our, physicians are healers. We're not fighters. And so our natural tendency is to spend time explaining. But if the question is quite simple, in a deposition, your attorney will tell you, look, just answer the question. You don't need to go off on a long rant, or you don't need to go into significant detail. Stay focused. In a deposition, your goal is to get in and out as quickly as possible, not to spend 8 hours in front of a court reporter. Anyway, takes a lot of time. And by the way, that's time you could actually be either in the exam room or the operating room, taking care of a patient and earning revenue. Almost every attorney will tell you this: do not talk about this case to anyone. Don't talk about it. And the truth is, it's very stressful. It's very difficult to hold this matter inside and not commiserate with anyone. Now, certainly you can talk with your attorney, because anything you say is privileged with your attorney. But if you start talking to your colleagues about the matter, you could be asked about the conversations you had with your colleagues, and then your colleagues can be brought into the matter to serve as a witness, perhaps a witness delivering information that may not be particularly helpful to your case. In fact, it may be the opposite of helpful. It may actually harm your case. Do doctors talk about their cases? Yes, they do. Do they talk in generalities? Sometimes. Sometimes they go into detail. But if you're dealing with an auto accident case, there's not a whole lot at stake typically. I guess there is a fair amount at stake if you admit to a colleague or a friend that you had 4 drinks before going out on the highway before you got into a fender bender. But most of the time, the stakes are not as high as it might be with professional liability. One thing that you would hope is that the system is reasonable and fair, but over time, what the system has delivered is that settlements and judgments are more related to the type of injury and the amount of injury, as opposed to the likelihood of negligence. So if a patient dies, if they become blind, if they lose a limb, if they are tragically disfigured, the likelihood of a payout is higher. Why? Because that has jury appeal. If somebody comes in and it looks like half their face sloughed off due to an embolism in an artery, that's going to have a lot of jury appeal. You would hope that this could be settled in advance of going in front of a jury. But the question is, if you did nothing wrong, why would you want to settle? If you didn't stray from the standard of care, why would you be inclined to actually even settle? But because of this, because juries are swayed by the extent and the severity of the injury, that dries up the cost of playing poker. Next, if you settle a case or pay a judgment, you'll need to, that will linger with you for a period of time. You'll need to detail this in your record when you apply for licensing going forward. That means renewing your license or applying for a new license in another state. And with your hospital privileges, being credentialed in any facility, they'll ask, have you settled a case? Have you paid a judgment on a case? And if the answer is yes, they're going to want details of that. Next, settlements and judgments sometimes appear on state licensing board websites. Every state is different. Some states require reporting to the medical board, depending upon some threshold number. So in California, if a settlement is made for more than $30,000, you got to write a check. I'm sorry, you have to report that to the state licensing board. In Virginia, the number is lower. I think it's on the order of $10,000. But some states actually publish this. They'll say whether you have had a settlement or judgment above some threshold value. So patients can look this up. And it probably doesn't go into the details of what happened. I mean, certainly an enterprising prospective patient could go to the clerk of the courts and pull out the files and try to figure out whether a court ruled against you or jury ruled against you, but most of the time they're not going to do that. Next, the settlement and judgment. If paid by a carrier, not paid by you, but paid by a carrier, will be deposited in the National Practitioner Data Bank. The National Practitioner Data Bank is accessible to those with a need to know. That would be a hospital credentialing committee. It could be your professional liability carrier. It could be third-party insurance carriers, licensing boards. So the National Practitioner Data Bank, in theory, is protected from the public, but by and large, your professional career depends upon having the least controversial and cleanest data bank report. So you really want to minimize the amount of line items in your report. The more line items, the more questions that are posed. And you certainly have an opportunity to put in a subject statement as to what happened, but this is perceived as words coming out of your mouth and will be perceived as somewhat self-serving. So, I mean, the fewer line items you have in your data bank report, the better off you'll be. Next, when you go to court, it is a battle of the experts. Each side hires their own experts, and the other expert may be tremendously charismatic, but may deliver nonsense. And if he's charismatic while delivering nonsense, obviously that needs to be rebutted by your expert, but charisma may carry the day here. And a jury may find the other expert's delivery quite credible and compelling. The single time I was sued by an expert who had actually been previously expelled from our professional society for delivering frivolous testimony. Yet his testimony was ridiculous. Nonetheless, he was a professional expert. He made a lot of money testifying. He'd never seen or done the procedure at issue, but that didn't prevent him from having an opinion. And while the case was dropped before trial, I can tell you that here the other side found an expert who was ready, willing, and able to say almost anything, even though he had been previously expelled from our professional society. So this can be maddening. You could potentially hear an expert on the other side deliver nonsense. It may very well be that they deliver the truth, but this is part of the challenges faced in our professional liability system. All right. A judge will typically instruct a jury to not talk about the case. In particular, don't go onto the internet and look at information. The case should be limited to data and information that each side delivers. Some things are kept out of trial, and the judge, serves as the gatekeeper for that. And the judge will often say, whatever you do, don't go to the internet and see what other people are saying about this case or about this doctor. Do people on a jury do this? They do, and there's no way to police this. I mean, they're human, they're curious, and it's not unusual for them to go to the doctor review sites or to social media sites to see what others are saying about this doctor. And does it color their opinion? I think it does. So, for example, if a collection of reviews about a doctor mostly follow this byline, arrogant, uncaring person who never listens, that's not particularly helpful. But if the general consensus is thankfully got out of bed at 2 in the morning to save my mother, that probably helps you. So I tell most of my colleagues, to the extent you can buttress and build up your reputation with positive reviews in advance of a patient getting a complication, in advance of getting sued for professional liability, do it. There's no downside. I guarantee you that jurors will spend some time looking to see what others are thinking about you. And you'd rather be that doctor that said, thankfully got out of bed at 2 in the morning to save mom, as opposed to arrogant, uncaring person who never listens. The two systems have little in common. I mean, how often are you in a car accident? I don't know. I guess most people are in a fender bender in some capacity. I'm trying to remember the last time I was in a car accident where I had to turn it over to my insurance company. Certainly, my universe expands if you're including my extended family, which would be my wife and my daughter. But if you're a doctor in a high risk specialty, the likelihood of you being sued over your career is quite high. This is a nice graph. It's a little dated now, it's from 2011, but it just showed the aggregate risk likelihood of being sued and whether a judgment would be paid out, settlement would be paid out over time. And you can see that in a high risk specialty such as neurosurgery, the likelihood of going an entire career without ever being sued is close to zero. Put differently, the likelihood of being sued in a high risk specialty over your career is close to 95, 98, 99%. Even in a low risk specialty, low risk meaning psychiatry, pediatrics, family practice, over your career, the aggregate risk is about 75%. So even in low risk specialties, it's hard to dodge the bullet, if you will. All right. So the original question, which was posted on a bulletin board, was about a doctor who actually committed suicide, and he settled after a horrendous lawsuit. It was drawn out, and it truly impacted him. And so the question is, did that lawsuit cause his suicide? And the answer is, I have no way of knowing. Was I shocked that it happened? I really wasn't. Was he likely predisposed to being depressed? I have no way of knowing that. But I do know that if somebody is predisposed to depression or burnout and then they are sued, the likelihood of this turning into a more catastrophic mental health challenge is significant. And I think for most people who have gone through litigation, they describe the process as being alone. They feel like they've got nobody they can turn to. It is quite stressful. It interferes with their daily life. They start to perceive patients as potential plaintiffs. It interferes with their family relationships, with their spouse and their children. And it also makes it more challenging just to be enthused to take care of your patients. Um, so burnout is something that can be exacerbated by the stress of litigation. Now, the good news is there are tools that you can use. There are people that specialize in this and people that have been on the receiving end of a lawsuit. I'm one of them, actually. I went through litigation and it was amazingly stressful. I had moved to North Carolina from Indiana, and I had to fly back and forth to deal with all of the issues related to this case. I had a child with special needs, autism, and epilepsy, so there was a lot going on. And I can tell you, it was quite stressful. Nonetheless, I now understand the process, and having worked with thousands of physicians who have also gone through the process, we can certainly give guidance general guidance on how to manage it, certainly how to manage the stress. So anyway, I founded my organization, Medical Justice, as a way just to help doctors navigate through this process of uncertainty. Um, and it was birthed primarily because I was sued for a frivolous reason. But any event, let's just talk about what professional liability lawsuits are. They are an assault on your reputation. They are time sucks. They are stressful. And the lawsuits themselves and their outcomes may be reportable to a host of entities, including boards of medicine, the National Practitioner Data Bank, hospitals, your specialty board, and insurance carrier. And to the extent you make a settlement or you have to pay out a judgment, many of these entities will want that proactive notification, that you have an obligation to notify them. Every state is different, every carrier is different, all these entities are different. I mean, for most of them, they can just get this information with a continuous query of the National Practitioner Data Bank, but some of them mandate that you actually have to affirmatively let them know within 30 days what happened. So if you've got licenses in 30 states, by being part of the Interstate Medical Licensure uh, Pact, you may have an obligation to notify 15 of them of a settlement or judgment. Something to think about when you're going through the process of collecting all the cards with multiple licenses in multiple states. Next, a professional liability lawsuit may not be the end of the matter. It may lead to action with the Board of Medicine. And by the way, to prevail in a medical malpractice lawsuit, the plaintiff has to prove a number of things. One is that there's a doctor-patient relationship. Number two, that you owed that patient a duty of care, not to breach that standard of care. Number three, that breach caused. Number four, damages. So lots of things that a plaintiff needs to prove to prevail. A medical board isn't interested in all of those things. They're mostly interested in, did you breach the standard of care? If that caused damages, that may be interesting to them. It may not, but it's not a requirement, meaning a board of medicine can take action and open an investigation strictly with a breach in the standard of care. And then finally, medical malpractice lawsuits are part of the practice of medicine. If you get to practice till you're in your 60s and 70s, the likelihood of you being sued in a high-risk specialty is close to 99%. Even in a low-risk specialty is about 75%. Now, the good news is the likelihood of a payout, either by settlement or judgment, is lower, much lower than that. Most of the time, you will either be dismissed from the case or you will prevail. But that goes back to the some of the original bullet points here, which is professional liability lawsuits are stressful. All right. I appreciate your attention. Feel free to reach out to Medical Justice if you either get an intent to sue, or you are sued, or trying to deal with the fallout of the aftermath. But we will have additional videos on many of the nuances of medical legal risk. Thank you.